So the Ninth Circuit en banc panel just issued their decision finally in the California magazine ban case Duncan versus Bonta. And it's exactly what we all expected, nothing surprising. However, now this sets up a very critical magazine ban case to finally make its way back to Supreme Court and deal with magazine bans finally. Now, before we jump fully into breaking down this decision and talking about the implications for everybody, not just in California, but nationwide, make sure you like, comment, and subscribe on this video, share it around, and also just drop a positive comment down below because that helps to tell the algorithm that you enjoy two-way content, you enjoy these types of videos, and it should share my video and other people's video to more people. Now, like I mentioned in this video, we're going to be talking about just generally the decision that was just issued by the Ninth Circuit en banc panel in the Duncan versus Bonta case, which deals with the California magazine ban case. Again, this is not going to be a super comprehensive video on everything that was mentioned in the Duncan case. Maybe I'll do that later, but I wanted to give you guys a broad overview of what the Ninth Circuit en banc panel just said in the majority opinion, some of the dissents that were issued, and then just what happens now going forward. And I know a lot of people will potentially have questions about, your Freedom Week magazines and what potentially is lawful going forward. Now, like I mentioned, the Ninth Circuit en banc panel just issued their decision. The majority opinion essentially is upholding the California magazine ban once again. Now, like I mentioned, that's not super surprising because we all knew that the Ninth Circuit en banc panel took this case as a comeback case for a very specific purpose, and that was to once again uphold the California magazine ban. They broke some of their rules with the express intent of upholding this magazine ban. But what this does is it now sets up this critical Duncan case, which was already in front of the Supreme Court before, and was granted, vacated, and remanded after Bruin back down to the Ninth Circuit. It now sets this case up to go back to Supreme Court on the final merits, and this is potentially the magazine ban case that the Supreme Court has been waiting for. We were all kind of looking at the Snope case and then also the Ocean State Tactical case and how those were being relisted multiple times, and it could have been that the Supreme Court knew that this Duncan case was going to be issued and they were waiting for it to make its way back to them. So let's look at the majority opinion, some of the things that they state, and then I want to point out some of the things in the dissenting opinions, including a video that was issued by Judge Van Dyke as a dissent, which was very interesting. I haven't seen that happen before, especially out of the Ninth Circuit en banc panel. Some of the majority opinion took issue with that video, which is also very interesting. And then we need to talk about what are the major implications for people in California with your Freedom Week mags, because I know people will have questions about that as well. Now, the majority opinion issued by the Ninth Circuit en banc panel stated that employing the methodology announced in Bruin and recently applied in Rahimi, we again conclude that California's law comports with the Second Amendment for two independent reasons. First, the founders protected the right to keep and bear arms, not the right to keep and bear arms and accoutrements, a common expression at the time of the founding. Large capacity magazines are optional accessories to firearms, and firearms operate as intended without a large capacity magazine. A large capacity magazine is thus an accessory or accoutrement, not an arm itself. Possession of a large capacity magazine therefore falls outside the text of the Second Amendment. So that was one of the first findings of the majority in the Ninth Circuit. Second, they state, even assuming that the text of the Second Amendment encompasses the possession of an optional accessory like a large capacity magazine, California's law falls neatly within the nation's tradition of protecting innocent persons by prohibiting especially dangerous users of weapons and by regulating components necessary to the firing of a firearm. California's law is relevantly similar to such historical regulations in both how and why it burdens the right to armed self-defense. Like those historical laws, California's law restricts an especially dangerous feature of semi-automatic firearms, the ability to use a large capacity magazine, while allowing all other uses of those firearms. So far as California's law is concerned, persons may own as many bullets, magazines, and firearms as they desire, may fire as many rounds as they like, and may carry their bullets, magazines, and firearms wherever doing so is permissible. The only effect of California's law on armed self-defense is the limitation that a person may fire no more than 10 rounds without pausing to reload, something rarely done in self-defense. The justification for California's law is to protect innocent persons from infrequent but devastating events. California's law is not a precise match to the historical laws, but it does not need to be. By prohibiting only a especially dangerous use of modern weapons, the law comports with the principles underlying the Second Amendment. We reverse the district court's contrary conclusion and remand with instructions to enter judgment in favor of defendant Rob Bonta and the state of California. So that was the opinion of the majority here in the Ninth Circuit en banc panel. Like I said, not surprising. They say that magazines are not arms. They're not protected by the Second Amendment, that they are simply accoutrements or accessory, and as accessories, they are not needed. They also state that this California law here does not burden the right to self-defense because you can have as many 10-round magazines as you want. You can have as many, rounds of ammunition as you want, and that this does not impact your right to self-defense because you don't need more than 10 rounds to defend yourself. And so again, that's a very interesting thing that the Ninth Circuit is heavily relying on. Now, like I stated, there were dissents in this opinion from multiple judges. One of the interesting ones was from Judge Van Dyke, who was also very vocal in oral arguments in the Ninth Circuit en banc panel. And also he wrote a ton of briefs, kind of talking about his colleagues, talking about how they do not actually support the Second Amendment, how they directly want to strike down the right to keep and bear arms. And in this video from Judge Van Dyke, which I will link down below, I'll put it in the pinned comment that you can watch, he kind of breaks down how a handgun operates. He uses a SIG 320. I believe it even looks like a Legion. He talks about, how that works, how you can pull out the actual firearm and change grips, and how you can change magazines. So he kind of uses that to walk through and talk about how his colleagues and how the state of California itself don't actually understand how firearms operate and how the Second Amendment should also operate to protect those items. Now, the majority also took issue with this video being used by Judge Van Dyke. They talk about how this flouts judicial rules. They state in the majority that in providing a physical illustration of how various handgun components function and how to replace them, Judge Van Dyke presents demonstrations that have not been subject to the vetting procedures normally afforded to such evidence. Now, what's very interesting about this is the majority seems to take big issue with Van Dyke potentially breaking some rules by using a video in his dissent, but the entire Ninth Circuit broke their rules to take this case as a comeback. So their hypocrisy really has no bounds. They talk about how Judge Van Dyke broke rules, but they broke rules themselves to take this case. And that hypocrisy of the Ninth Circuit is actually pointed out by Judge Nelson in his dissent. Judge Nelson states in his dissent that I agree with Judge Bumate that the majority's decision to reverse the district court on the merits flouts New York State Rifle and Pistol Association versus Bruin. But the majority didn't just butcher the Second Amendment and give a judicial middle finger to the Supreme Court. It also spurned statutory procedure for en banc proceedings. As explained in my dissent from the order filed concurrently with this opinion, this en banc court lacked statutory jurisdiction to decide this new appeal, years after it remanded it for prior appeal to the district court. So there's a lot going on in this majority. Again, in the majority opinion, it doesn't really change much. We knew exactly how they would rule. We knew that they were going to say that magazines are not arms, that they're not protected by the Second Amendment, that you don't need more than 10 rounds for self-defense. They were going to try to say that Bruin and Rahimi don't change the outcome of this case, and that's exactly what they did. The interesting parts really come in some of the dissents where, again, they're calling out their colleagues for breaking the rules to take this case as a comeback. And then that very interesting video from Judge Van Dyke where he breaks down and demonstrates how handguns actually operate, what type of magazines we are talking about here in this case, and just generally the impacts of this case, talking about how accessories and other accoutrements aren't protected and how that could impact things like the SIG 320 and other firearms as well. Now, what is the practical impact of this decision on you guys here in California? I know a lot of people are going to be having questions about their Freedom Week magazines. As of right now, this decision does not change in that. We don't have the mandate yet from the Ninth Circuit, and we're not going to get that anytime soon because this case is going to go back to the Supreme Court. I have no doubt that there's going to be a writ of cert to the Supreme Court to once again review this issue. And because of that writ of cert, there's likely going to be a hold on the mandate being issued by the Ninth Circuit. And without the mandate, it doesn't really change the status quo of Freedom Week magazines or anything like that. And one of the interesting things with this is we kept seeing the Snope in the Ocean State Tactical case kind of go back and forth with relists. It could have been that the Supreme Court knew that this decision from the Ninth Circuit was coming very soon, that the Duncan decision was going to be issued. And so maybe they were stalling to get that case back in their hands. So again, unfortunate decision, but this is generally, what we expected. And we knew that the, case wasn't going to be over after the Ninth Circuit issued the Duncan decision. We knew that this was going to be elevated once again to the Supreme Court. And I suspect that's exactly what's going to happen. So as we get more information, I will let you guys know. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And don't forget, this station was built by armed scholars, and the station will be maintained by armed scholars.